Welcome, everyone. We are pleased that you have joined us for today's webinar titled Estate Planning for Real People. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you, Amber, and hello, everyone. Good morning or good afternoon, depending on where you are. Glad you joined us today. We're going to talk today about estate planning for real people. I'm going to talk about some of the questions that I get asked now and that I used to get asked when I was a practicing estate planning attorney by folks who were trying to sort out what they wanted to have happen in the event of death. And I think it's good for those of us who are in the life insurance business and in the financial services business to have some background about that kind of stuff so that we can give sensible answers to people as they think about estate planning before we send them off perhaps to work with their attorneys on some of the questions. Before we get into today's content, let me tell you that in January, we've already decided on a topic. I know we normally have a poll, but today we've already decided on a topic. We're going to give an update on key numbers for 2022, income tax, estate tax, pension numbers for 2022. That session will be on Wednesday, on January 5th. This is always the first Wednesday of the month at 11 o'clock Central Time, and the webinars are free of charge. If you find the content useful and you know of somebody else who might find it useful, please feel welcome to pass word along to others who may benefit from joining us for these short webinars. As you know, they generally last about 15 or 20 minutes. So let's get right into today's topic. Let's talk about estate planning for real people. Here's our hypothetical real couple who perhaps are thinking about creating estate planning documents, and they have some real questions. And the first question that they might have is, what is probate and why should I avoid it? Question came up all the time for me. We'll talk about that. Second question is, explain about trustees and executors and who I might pick for those jobs if I have a trust or a will in my future. People want to know, does it make sense for them to give stuff away now? One thing that they might ask or might not ask, but that we should be prepared to talk to them about is the answer to, how can I protect my special needs relative? And the thing that a lot of people are really thinking about that they might or might not ask is, how can I keep peace in my family after I'm gone? That's always kind of an interesting question to deal with, and I've got some thoughts on that I'll share with you here in a second that you might want to share with your clients. So let's start with, first of all, what is probate and why should I avoid it? And I think a lot of times people who answer this question give a more complicated answer than is necessary. From my perspective, it's pretty simple what probate is, and that is, probate is the court supervising the transfer of somebody's stuff at death. That's all it is. It's the court supervising the transfer of stuff at death. And on its face, that sounds pretty simple and pretty positive, right? It's just somebody looking over how stuff is transferred in the event of death. What are some of the downsides of probate? Well, the first downside is that it's public. And what does that mean? Well, it means that if somebody passes away either with a will or without a will, and they've got a lot of stuff that is in their name, the transfer process is going to be the probate process, and probate is a court proceeding, and therefore it's public. Somebody can run down to the courthouse, ask for a copy of a particular probate file, and odds are they're going to be able to get all of the information about somebody's stuff and about somebody's distribution intentions by doing that. And so if a family is interested in privacy after death, it is important that they make plans to avoid probate, so that the publicity of the court proceeding, isn't available to nosy neighbors or nosy public for celebrities. The second reason why people probably want to avoid probate, all things being equal, is that it is highly structured and it takes time. There's paperwork involved in probate. Paperwork has to be prepared to the satisfaction of the probate judge, and that process isn't for most people. Most people would get frustrated by having to kind of go through that process. It's easier in some places than in others, but in general, the structured nature would be frustrating for most folks. In addition to that, probate takes time. Part of the probate process is to let creditors know that somebody's passed away, and so if a creditor has a claim on a decedent's stuff to satisfy debts, those creditors have to be given an opportunity to let the court know that this process is taking place and to submit claims if they think they've got valid claims against a decedent's estate. Furthermore, if part of the process is letting relatives know that somebody's passed away and letting them know officially, and that process takes time. And what I'm fond of saying is that it takes about a year from start to finish to go through probate if things are going well. If things are not going well, it can take much longer. I've certainly been involved in probates where the process took 3 years or more because family couldn't get together on what needed to be done, and there was a lot of arguing, and that can be a real barrier to the probate process. And so structured and takes time is another reason why people might want to avoid probate. Third reason that people might want to avoid probate is decedent's creditors may get paid. I alluded to earlier that part of the structure of probate is to let creditors know that somebody's passed away, and that if the creditors have legitimate claims against the decedent's stuff, there's a process for making sure that those legitimate creditors get paid. If money that doesn't have to go through the probate process is forced through the probate process, creditors may get a crack at that money in a way that they wouldn't normally have gotten a crack at it. What am I talking about? Well, I'm talking about, take life insurance, for example. Life insurance with a named beneficiary, if the decedent passes away, the decedent's the insured, normally creditors wouldn't get a crack at those life insurance proceeds that are paid to a named beneficiary. However, if the estate is the beneficiary, those creditors may get a crack at the money. Depends on the rules in the state where somebody somebody dies in, but why risk it? Why potentially make those life proceeds subject to the claims of the decedent's creditors? And so it's another reason to avoid probate. It's because decedent's creditors get a crack at the stuff. It can be expensive to go through the probate process, and expensive not only in terms of money, because there are filing fees, and an attorney is hired, attorney's fees that are associated with probate, but it's expensive in terms of time. It takes a lot of effort to get through the probate process because it is structured, and one way or another, that creates an expense for whoever's going through it. And so the expense of probate is something that can be avoided if there's an alternative that also meets a client's needs. And then the last thing is that it's best in probate to use a lawyer. Lawyers have done it before. A good lawyer who's been through probate before can end up saving a lot of time and effort in the process, can end up being a guide through the process. That's the good news. The bad news is that you got to pay a lawyer for that. And a lot of people have a knee-jerk reaction to lawyers and don't want to use them if they can avoid it. And so because people don't necessarily want to interact with lawyers, they may want to avoid the probate process. So that's what probate is, and that's why people either should or shouldn't use it. So let's talk about trustees and executors. And to me, those jobs are really, really similar. When somebody is trying to name a trustee of a trust or an executor of their will, an administrator of their estate, they should be picking the person or people or the institution that are going to be in charge of doing the cleanup and administrative work after death, right? That's what the job of the executor or the trustee of any trust is. It's doing cleanup work, doing administrative work. And so you want to pick person, people, or institutions that have the skill set to carry that off in the right way. From my perspective, the first characteristic of the right person, if you're picking a person, is that the person is financially responsible. It's why banks and other institutions end up being trustees or sometimes executors. They are financially responsible, and so the level of care that they provide is strong because they don't want to incur liability for doing things wrong. You want somebody in that job who is emotionally stable, right? There's a lot of work involved with cleanup and administrative work. A lot of times emotions inside the family, if things aren't going the way that somebody expects, the emotional stakes can be high. And so you want somebody in charge of the overall direction of this to be emotionally stable so that things don't get worse if family is bickering over the process. You want somebody who's highly organized. I mentioned earlier that probate is a structured process. Trust administration is also a structured process. You want somebody who is organized, who can keep records together, potentially show them to a judge, potentially show them to family members to show what it is, what has been done. That skill set is needed in a trustee or an executor. Obviously, you want somebody who is trustworthy. You don't want somebody who's going to potentially cheat other people. That's a recipe for disaster in either a trustee or an executor. And you also want somebody who is a rule follower. Probate has a lot of rules associated with it. In many probates, you're administering rules created in a will. And so respecting those rules is important. In trust administration, you've got a trustee who is following the rules of the trust. And so if you've got somebody in those jobs who is a natural rule follower, that is a characteristic that will help that person be successful in being a trustee or executor. And so if your clients are trying to pick trustees or executors, this is a pretty good list for the qualifications for the job if they're going to pick family or if instead they're going to hire a professional trustee or executor. Does it make sense to give stuff away right now? Clients may decide that instead of going through the trouble of putting together a full-fledged estate plan, they're going to give away some or all of their assets right now. Now, there are lots of reasons why people might choose to do that. But some pros to giving stuff away right now is that if younger heirs get stuff, particularly money right now, they may be able to use it for a business opportunity or other growth opportunities that would put them in a good financial spot later on. And so it may be in their interest for the older generation to give stuff away now rather than later. Obviously, we talk about giving stuff away to avoid death taxes, federal estate taxes, or state inheritance taxes or estate taxes. Gifts made now may help to manage those issues later on, and so it's another reason to think about gifts. It's an easy thing to do. It's an easy thing to write a check to a relative, and you know, as long as there's no gift tax consequence involved, it's something that can be done, you know, pretty much in a minute. The main downside is loss of control. Sometimes people are considering making gifts in connection with Medicaid planning so that they can make themselves poor and potentially qualify for Medicaid later on. And the biggest reason for them not to do that is the loss of control over the asset that's given away. And so balancing that loss of control against some of the positives of making gifts is really the key thing for most people that needs to be thought about in determining whether or not making a gift right now is good or not. If an asset's given away, it's not available reliably for support. If support is needed for the giver, and it just needs to be thought about. And then, you know, another thing that we sometimes talk about is income tax basis in the asset. If it's a capital asset that's given away in general, the recipient gets the donor's basis. And so if the donor's basis is low, when the recipient ultimately sells the underlying capital asset, there'll be capital gains tax to be thought about. Whereas if somebody leaves an asset at death to the heir, there's generally for a capital asset, there's a step up in basis so that the heir gets a new basis when the capital asset is inherited that's equal to its fair market value. At least that's the rule that's still in place today. And so, you know, from an income tax perspective, from the heir's point of view, inheriting can be more efficient income tax wise than getting a gift, particularly of a capital asset. So those are some of the moving parts in the discussion about whether it makes sense to give stuff away now. For special needs relatives, well, sometimes in families we know about circumstances where family members have special needs, sometimes a special needs child, for example. Sometimes we don't know about it and we have to ask about it specifically to find it out. But where a family member's got special needs, if they get a direct inheritance, sometimes the direct inheritance will screw up their needs-based benefits. And so the older generation needs to think pretty carefully about how assets will be allocated to special needs family members. And usually what we're talking about there is a special needs trust. This is sometimes called a supplemental needs trust. The point of the trust, or one of the points of the trust, is to make money available for a special needs beneficiary, but make it available in a way that doesn't screw up the beneficiary's access to needs-based government benefits. And so if we put money in a special needs trust that is written in the right way, the assets in the trust don't count against the special needs benefits for the purpose of qualifying for those benefits. A special needs trust can be drafted to exist right now, and stuff can be put in it right now. Or it can be a trust that comes into existence when the parents, for example, when the parents die and the special needs child, you know, is in line for stuff. The special needs trust can be created in a will that springs into existence at the second parent's death, and it gets funded at that point. And that's another way to make an effective special needs trust. Either possibility may work. In my experience, it's more common for these trusts to be testamentary. One other advantage of having a special needs trust to protect a special needs relative is that the trustee can can and should manage the money on behalf of the special needs person, and that can be a positive thing. In addition to protecting against the loss of government needs-based benefits, the management provided by the trustee can end up being a positive thing and help in the financial well-being of the special needs person. And usually these trusts are written in such a way so that whatever's left over when the need for the special need relative ends, whatever's left over is available for family. And so, those are all the positive objectives that can be achieved with a special needs trust that's thought about in advance. One of the downsides is that it's more expensive to have a trust than it is to leave stuff outright to a family member. And so the potential positives need to be weighed against that administrative expense. And then the last question that we often get asked is, how can I keep peace in the family after my death? And I always kind of chuckle over this one a little bit because a lot of people have been unsuccessful in having peace in their families during lifetime, and they think somehow that having the right words in a testamentary document is going to create peace after death. It doesn't really work that way. But there are some positive things that people can do. I think having a written plan certainly makes things easier because it makes distribution intentions clear. And while family members may not like what somebody has decided with regard to distribution, if uncertainty is off the table, at least that's not a source of anxiety, right? The written plans, hopefully clearly spell out what the decedent had in mind and maximize the chances of family getting along, even if they don't like what the decedent has written down. One of the other things that somebody can do to try to maximize the chances for peace after death is to have a family meeting. I called it a family summit here, but to have a family meeting during lifetime where these things are discussed openly and the decedent's wishes are set out, but the concerns of the family members are also potentially laid on the table. That has the potential in a good working family to have positive effects. It can also go the other way. So it's certainly not for everyone. A person being able to put trusts inside of their will documents to manage family issues, manage potential black sheep family members, that's certainly something that ought to be considered. Taking some steps to treat everybody in the family fairly, that's important. Most clients have that as an objective. Some family members have different ideas about what it means to treat everyone fairly, and so that can be a kind of a tricky thing to work out, but that's certainly an objective that can be pursued. It's particularly important in blended families. If we've got second or third marriage where we've got yours, mine, and perhaps ours kids as part of it, thinking about that in a way that treats everyone fairly is important to do and important to incorporate in any documents. And if it's any comfort to those of us on the call, all of us aspire, I think, to be the Waltons in terms of our family relationships. Unfortunately, most of us are more like Modern Family, I think, rather than the Waltons. And so relationships end up being really, really complicated. And so thinking about those issues and sorting them out in a written document, it's a hard thing to do. And I think it's important for us to keep that in mind as we're working with our clients. We're aiming for as good as we can do. We can't mold every family into the Waltons, particularly if it's only going to happen after somebody dies, or in somebody's mind, it's only going to happen after they die. So I hope that was helpful to you. Those are the real questions, I think, on the minds of our clients. I think we need to be prepared to answer them, help our clients think about the big pictures, but to clear out those things the clients are worried about so that they can see the big picture. I think that's a good thing. I think there's a tendency for those of us in the life insurance business to talk in code and focus on the things that are of direct interest to us. I think if we fail to recognize that our clients have other things on their minds about estate planning and fail to address those things, we've got the potential to not communicate effectively with them. And I think that that's really a recipe for disaster. I think if we want to serve our clients well, I think we start with the listening process and find out what they have in their minds and answer their questions as well as we can. We're trying to fill the information gap. We're trying to work effectively as part of a team. And, if financial products are needed to make all of this stuff hang together, well, that's the time to propose that stuff, not on the front end. I want to thank you again for joining us today. And at this point, I'm going to turn the program back over to Amber to wrap us up. Amber?
Thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, which will be January the 5th at this same time. Next month's webinar will discuss updates on key numbers for 2022. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.